Moving on, we will talk about a recent decision on priority, which clarifies priority of judgment mortgages. To begin, what is a judgment mortgage? Judgment mortgage arises after obtaining a judgment against a debtor, registering it on either registered or unregistered property. Give the registrar of the judgment mortgage priority over unsecured creditors of that debtor. The priority of judgment mortgage depends largely on the conflict between Land and Conveyancing Law Reform Act and Registration of Title Act. Under Section 117, Subsection 3, the judgment mortgage is subject to any rights or encumbrance affecting the judgment debtor's land, whether registered or not, at the time of registration. Yet, under Registration of Title Act Section 68, Subsection 3, an unregistered right in or over registered land shall not affect the registered owner of a charge created on the land for valuable consideration. Moreover, under Section 74, the priority of burdens on the register is right according to the date of their creation. Question is whether an executed charge not registered at the point of execution ranks in priority over a judgment mortgage which came into being after the first charge was executed but was registered before the first charge. In the case Industrial Credit Corporation, in addressing that controversy, Carroll J. identified a possible inherent contradiction. He further suggested that the conflict can be resolved by treating the payment of loan monies as having created an equitable charge. In 2017, the case Lariano Foundation and Leo Prendergast and Sons Limited provided an even clearer answer to the question. The case involved the plaintiff seeking an order of property belonging to the defendant. In reality, the dispute was between the plaintiff and the notice party to the case. Both parties lent money to the defendant and sought to recoup from the sale of the property, which they argued they were entitled to priority over. Believing that the defendant would provide a legal charge over the property, the plaintiff lent money to the defendant. Even though the charge was never executed, the defendant confirmed that they held the title deeds to the property on trust for the plaintiff. The plaintiff failed to register, thus rendering this equitable charge useless against the notice party, a competing secured creditor. In 2011, the plaintiff sued the defendant and obtained a judgment mortgage, which was later registered. In between 2004 to 2006, the notice party provided the defendant with 3 separate loans. Unlike the plaintiff, the notice party obtained an executed charge over the property and registered within the time frame. So, the key question was whether the plaintiff's 2012 judgment mortgage should take priority over the notice party's 2004 charge. The court based its decision primarily on Section 117, Subsection 3 of the Land and Conveyancing Law Reform Act 2009, which states that the judgment mortgage is subject to any rights or encumbrance affecting the judgment debtor's land. Even though the court recognized that there was a contradiction between the legislations, the court noted that to the extent there was any contradiction, it will be resolved by applying the maxim, the general does not derogate from the specific. Consequently, the specific provisions relating to judgment mortgage, which expressly states that they are subject to existing rights and encumbrances, will be given effect too. The decision provides both a welcome confirmation for secured creditors of the primacy of a charge over a judgment mortgage, and also a salutary reminder of the need to ensure that the lending process is carefully managed.
Created using Powtoon.